Hello and welcome to this video about theft. We're going to be having a look at the provisions of the Theft Act 1968. Remember that you need to know the years for acts but not for cases. The whole of the law is found in sections 1 to 7 of the Theft Act. This was a consolidation act and it was supposed to make the law simpler, but it's been enforced for a long time now and there have been an awful lot of cases which has made the law more complicated as some of them conflict. I have tried to indicate the key cases by putting them in red, so they are the ones that you really need to know, and then all of the other ones are extras which would be good to know. So section 1 states a person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. So let's see how this breaks down into the AR and MR. And you can see that the AR is in sections 3, 4 and 5, appropriation of property belonging to another. And then the mens rea is in a further 2 sections, sections 2 and 6. So dishonesty is in 2 and the intention to permanently deprive is in 6. So section 1 defines the whole offence, and these sections 2 to 6 define the elements that you need to prove for there to be a theft. And you need to prove all of them for there to be a complete theft. So let's start by looking at appropriation. Appropriation is defined as any assumption by a person of the rights of an owner. This is a very wide definition, which is wider than the previous words used, which just used to say taking. So appropriation, remember, is not the offence. The offence is theft. Appropriation is just the first thing that you need to prove. And if you look at the words in square brackets, including where he has come by the property innocently, a later assumption of a right, this covers the situation where you acquire the property without stealing it, but then you later decide to keep it. And this covers things like maybe borrowing a book from the library. So when you first get it, you're not stealing it, but then you later decide to keep it. And that is an appropriation at that point. And it's a similar situation where you are given too much change in a shop and you don't realise at the time, so you acquire it innocently, but then later you decide to keep the change, and that is the time when there is an appropriation. There is an exception in the Act for people who buy stolen property in good faith. So as long as you didn't know it was stolen when you bought it, then there will not be an appropriation. So let's look at a couple of the cases. The key case is Morris, where switching price labels even before you got to the checkout in a shop was held to be an appropriation, as it is an assumption of the rights of an owner. Only the owner has the right to change the price labels. And Pitham and Hale, where offering something for sale, in this case the furniture of someone who was in prison, was held to be an appropriation, as it is assuming the rights of an owner, as only the owner can sell their property. So when you're applying the law, make sure you say why it is an appropriation and say it is because only the owner has the right to do this. Note that there can be 2 appropriations, so you may have a situation where someone takes something and then they dispose of it. In both of those situations there could be an appropriation because you're assuming the rights of an owner. Only an owner can take it and only the owner can dispose of it. And that was the case in the case of vinyl, which is a case we'll come back to in robbery, because it's important in terms of timing, because the intention to permanently deprive only came in when they disposed of the bike, and the force was used when they took the bike, so there couldn't be a robbery because the robbery wasn't used at the time of or immediately before the offence of theft. There can also be an appropriation even where there is consent. So in Lawrence, the student consented to the taxi driver taking £1 but not £6. And similarly in Gomez, there was consent to taking a cheque which later bounced. And even though the victim consented to taking the cheque, there was still held to be an appropriation. Hinks is a case which is similar to the cases on consent, but it's where there was a gift. And this was made by a man with low IQ, and he gave the defendant £60,000 over the course of several months. And that was held to be an appropriation even though he had given the money to her. Obviously this would not be enough on its own to be theft. You would have to establish all the other elements, including dishonesty. Appropriation for the purposes of Section 3 takes place at a particular time and is not a continuing act. So in AQA, the cars were stolen in Germany, then imported into the UK, and they said that there was no appropriation when they brought them into the UK because the appropriation had already occurred overseas. So this is slightly different to robbery, where in terms of the timing of the use of force, they are prepared to hold that an appropriation is continuing. So if you use force just after a theft, then you may still be guilty of robbery. Lastly, note that there can be an appropriation even if the defendant leaves empty-handed. So touching the bag in Corcoran and Anderton was enough to amount to an appropriation, as only the owner has the right to touch the bag, and that's a robbery case as well, so comes in robbery too. So that's appropriation dealt with. Let's look at property, which is in Section 4, and the definition which you should try and learn is money and all other property, real or personal, including things in action and other intangible property. So money includes notes and coins in any currency. Real property is land and primarily things fixed to land, and things fixed to land include buildings. And someone in the 1970s was prosecuted for stealing Cleckheaton Station, which he had dismantled and removed brick by brick. He was found not guilty in the end on some other technical reason, but it is possible to steal a building fixed to land. Personal property is the one that you're most likely to find in the exam. This is going to be things like phones, computers, purses, that sort of thing. And the rather strange case is Kelly and Lindsay, where what was stolen was body parts, but that shows you what a wide definition it is of personal property. Things in action are things that can be enforced by taking legal action, and they're very similar to intangible property because they're things you cannot touch, and they're things like cheques, money in a bank account, and tickets. Intangible property is property with no physical existence. So, for example, in Marshall, although there was a physical ticket for the underground, the value in it was the intangible property, the right to actually use the underground. However, it doesn't include confidential information, which is dealt with as a tort. So in Oxford and Moss, the student was not guilty of stealing exam questions when he saw the paper. But in AQA, the teacher was guilty of theft as he actually took the piece of paper. It wasn't to do with the confidential information, it was with the fact he took the physical piece of paper. Section 4.3 deals with things that are growing wild, like mushrooms, flowers, fruit and foliage, and it's not an offence to pick wild mushrooms, etc., unless you are doing it to sell for commercial reward. Similar provision for wild animals. You can't be convicted of stealing a wild animal, but you can be convicted of stealing an animal in captivity, so that would be something like somewhere from a zoo or a pet. There's also separate provisions for stealing electricity in Section 11 of the Act. So that's Section 4 dealt with. Let's look at Section 5, which is belonging to another. Belonging to another is defined in Section 5. Property should be regarded as belonging to any person having possession or control of it, or having in it any proprietary right or interest. Now, normally someone both owns and possesses their property, and so there's no issue with that. But you can see this is a wider definition than just ownership. So you need to look in your scenarios at who has the legal interest in the property. This might be straightforward. Again, this is one of the things you need to decide. Is it a straightforward issue, or do you need to go into more depth? Who is the legal owner? It may be that you decide that you need to look at the person who has possession or control of the property, and you may need to note that someone can retain a proprietary interest even though someone else is in control of the property. So in the medal situation in Webster, the MOD retained a legal interest in the second medal, which was sent out by accident, even though Mr. Webster was actually in possession of it. Also note, in a key case of Turner, that you can be found guilty of stealing your own property where another person has possession or control of it. In that case, it was a garage where he had left his car to be repaired, and he took it away before he had paid for it, and he was convicted of stealing his own property, even though he said it didn't belong to anyone else, it belonged to him. The court said no, it did belong to another, it belonged to the garage because they had possession or control of it. And control is important when you're talking about abandoned property. things that have been put in a skip or a bin. And the owner of a property in Woodman did not know that the metal was there, but they still had control of it as it was in a disused building that had a fence around it and notices up. And so even though they didn't know it was there, the person that took the metal from the site could still be found guilty of theft, as it wasn't abandoned, it did belong to another. Similarly, in the key case of Rostron and Collinson, this was a golf ball case where the players had abandoned their balls because they'd gone into a lake and they'd been dredged. But this was still held to be in the control of the golf club, so the golf balls did belong to another. And then you need to think about the case of Ricketts, where taking bags left outside a charity shop was the issue, and the defendant said that these had clearly been abandoned. But the court said no, they haven't. The legal interest is with the givers until the charity shop takes delivery of them. There are some special provisions now that we need to look at in Section 5 about property being dealt with in a certain way and property that has been given by mistake. So these are the special provisions in Section 5.3 and 5.4. So Section 5.3 applies when someone acquires property, usually money, legally but under an obligation. So normally if you acquire money in this way, the defendant would now be the owner. But Section 5.3 states that where the property has been given to be dealt with in a particular way and it's not done, there can be theft as the property is regarded as belonging to the giver, the person that gave the money. And the key case here is Davidge and Bonnet, where money was given by flatmates for a gas bill and then the defendant used it to buy her Christmas presents. She had been given that money under an obligation to use it in a particular way. She hadn't done it, so she couldn't say that the money was hers. It was regarded as belonging to the people, the flatmates that had given her the money. A similar case is one of Wayne, where the man had raised money for charity by doing various events, and although he didn't have to give the charity the exact money, he was under an obligation to give an equivalent amount, which he failed to do, and this amounted to theft, as although the money had been given to him, he was under an obligation to give it to the charity. There's some very specific cases about deposits, which depends on the terms of the agreement as to whether there's an obligation to deal with a deposit in a certain way. In these cases, Hall and case of Kleinberg. In Hall there was no obligation and in Kleinberg there was, and you can go and look at those if you are interested in them. Now we need to move on to Section 5.4. Lovely picture there of Ronaldo, and I think we all know the answer to that question really, if you're earning £275,000 a week. So let's look at Section 5.4. If the defendant receives money or property by mistake, then they are obliged to make restoration. And this is quite often where the employer pays too much by mistake. It's called an overpayment. And if that is the case, then the money is regarded as belonging to the person entitled to restoration, i.e. in that example, the employer. And this was confirmed in Attorney General's Reference Number 1 of 1983, a key case. If the policewoman who was overpaid in that case had dishonestly decided not to repay it, she could be guilty of theft from her employer, who was entitled to restoration. So it's not just an employer that this section might apply to. It could apply to being overpaid in a shop or being given a better model, say, of a phone in a shop by mistake. If any property is received by mistake or money, then it is regarded as belonging to the person who made the mistake, which is the person entitled to restoration. So that completes looking at actus reus. Now we need to look at dishonesty. And the mens rea of theft is two parts: dishonesty and the intention to permanently deprive. And in itself, dishonesty is two separate stages, which you must always do. So let's look at the first thing, which is the Theft Act does not define the word dishonest. It does say motive is irrelevant, so it doesn't matter whether you're stealing the money to give to your elderly parent who has no money, because there is no Robin Hood defence. Doesn't matter why you do it, your motive is irrelevant. Doesn't matter whether you gain, so even if you destroy property, you can still be held to be dishonest because you don't have to have gained anything. And it also doesn't matter if you're willing to pay and say, oh, well, I've left you some money for it, so I've taken it. None of those things will help you with dishonesty. There is some guidance in section 2.1 as to what would not be considered dishonest. So these are things that are not dishonest. So 2.1a is if someone believes they have a right in law to the property. And so in Robinson, a key case, the defendant thought the victim owed his wife money, so he believed he had a right in law, so there was no complete theft and accordingly no robbery. In section 2.1b, you could believe that the other has consented or would consent, and this might be the case, for example, where you took money out of your mum's purse thinking that she would consent. And the case of Holden was a similar case where the employee thought that the supervisor would have consented because he had done so previously for other people taking old tyres from Quick Fit. And the last section is that you believe that the person cannot be discovered by taking reasonable steps. And this case of Small is one where the car had been abandoned and he didn't realise that you might be able to trace it through the number plate. And that leads into the last point, that the belief doesn't have to be correct or reasonable, it just has to be genuine. And they held it was genuine in Small. So section 2 is the first part of dishonesty, and the second part is the test in Barton. This is what some people would know as the old gauche test, which stood for a long time as the test for dishonesty in criminal law and has now been replaced by the Barton test. So if you find there's a reason why the defendant is not dishonest under section 2, they're not dishonest because they thought they had a right in law, the other would consent, or the other person can't be discovered, then strictly speaking you don't need to consider the Barton test. But it's good practice to say that if section 2 does not apply, then apply the test in Barton. And in a case where there's no suggestion that any of the exceptions in section 2 apply, then you should always use the test in Barton for dishonesty. And it requires 2 parts. And the first, little a, what is the defendant's knowledge or belief as to the facts? And little b, in the context of a, was the defendant's conduct dishonest by the standards of ordinary, decent people? So when you're applying it, you need to apply both parts. So if we take as an example the defendant in Akbar, the teacher who stole the GCSE paper, then the little a would be the defendant's knowledge or belief as to the facts was that you should not reveal the contents of an exam and that it is bad professional practice to do that. And in the context of A, ordinary decent people would think that the defendant's conduct was dishonest, and so the test for dishonesty in Barton would be satisfied. So the last thing that we need to look at is the intention to permanently deprive under section 6. And the first thing to note is it doesn't require the owner to be permanently deprived of the property. It's all about what the defendant intended. That is the key, and it's what their main aim or purpose was. The owner can still get their property back and the defendant can still be convicted of theft. So sometimes it's going to be obvious in your scenario. So if someone spends the money that they've stolen, if they sell the property they've stolen or they destroy it, it's obvious that they're going to permanently deprive the owner of it. And you don't need to go any further than that, really. But there are some more tricky areas that arise. One of them is Velumil, where the company director took the money from the safe, was going to return it, but he was found guilty of theft because he wasn't going to return the exact banknotes that he took, and so there was an intention to permanently deprive of those exact notes. Also note that if the property is left in the same condition and nearby, there may not be an intention to permanently deprive. This often applies to joyriding, and the abandoned car in Zarai was a similar case. And these are dealt with under section 12, which is a separate section about taking a vehicle without consent, which is a separate offence. But just note that that might mean that there isn't an intention to permanently deprive, because in those cases, their real intention is to temporarily deprive. Note again that timing might be an issue because you might not intend to permanently deprive the owner of it when you first take property, but when you later dispose of it, then you may have the intention then, and that can be important for when a complete theft is actually completed for the purposes, for example, of robbery, and we looked at the case of vinyl earlier. So the next part of section 6 that we are looking at is the words in section 6 here. A person appropriating property belonging to another without meaning the other permanently to lose the thing is nevertheless to be regarded as having the intention of permanently depriving the other of it if his intention is to treat the thing as his own to dispose of regardless of the other's rights. And this was the case in Lavender, which is a little bit more tricky because it was the case about the doors and the council, and he said he didn't want to permanently deprive the council of the doors, but they said, well, if you have treated the thing as your own to dispose of, then under this section you have the intention to permanently deprive. And so that was what was held. He treated the doors as his own to dispose of, even though they were still on a council property. This section might also be relevant in the rare case of someone taking something and intending to give it back if someone paid them for it, like a ransom or something like that. So if a defendant took property from V and said, well, you can have it back if you give me £5, then the defendant might say, well, I don't mean them to permanently lose it. I'm going to give it back to them if they pay me. But you still can't do that because you are treating the thing to dispose of regardless of the other's rights, because only the owner has the right to try and sell it like that. The last thing that we need to look at is borrowing, problems caused by borrowing and lending. So by using the word borrowing, by definition, you're intending to return it. But we've already seen in Velumil there was a problem with borrowing money because you have to return the exact notes. Section 6 does say that borrowing is not theft unless it's for a period and in circumstances making it equivalent to an outright disposal. So depending on how long you've had it and what you've done to it might be relevant. And in the case of Lloyd, there was held to be no intention to permanently deprive where the goodness, virtue and practical value of the property remains intact. And in that case, it related to films which had been lent to his co-conspirators to make pirate copies of, but they had been returned very quickly and they did have all their goodness and virtue still intact. By contrast, the batteries, for example, if someone took them, used them all and then gave them back, although they're returning the physical property, they have used up the goodness, virtue and practical value. And so in that case, you would have had the intention to permanently deprive. So lastly, just looking at sentencing, theft is an either way offence, and this means that if it was heard in a magistrate's court, the maximum would be 6 months, so for the less serious cases, and for the more serious cases heard in a Crown Court on indictment, the maximum would be 7 years. My top tips for scenarios in paper 1 is that theft and robbery are really important and can form up to 30% of the paper. They're often combined with the general defence of duress. You need to learn the structure and the case law, but having said that, don't just repeat it all because you need to focus on what the key issues are in the scenario. Combine elements if you can, so that if you have a robbery and a theft, you might be able to do all the elements of theft first and then just add in the extra bits for robbery. And lastly, as usual, there's no substitute for practicing, and if you can practice under time conditions, you'll really improve your work on theft. And that's the end of the video. Thank you.